Today, the Supreme Court hearing oral arguments in a case pitting the U.S. Postal Service against a former employee who says he was forced to choose between his livelihood and following his faith. Washington correspondent Evan Lambert is live. Evan, this case hinges on a provision of the 1964 Civil Rights Act.
Nichole, that law says it's illegal to discriminate against an employee based on religion. So far, lower courts have ruled against Gerald Groff, but he is now in front of a Supreme Court that has lately been supportive of petitioners bringing religious freedom cases. Former postal worker Gerald Groff says he quit his job as a carrier after he was required to deliver packages on Sundays, which he says is against his religious beliefs. Tuesday, the Biden administration argued that giving him off on Sundays created an undue hardship on the post office, a legal standard upheld by a lower court.
And his absences created direct, concrete burdens on other carriers who had to stay on their shifts longer to get the mail delivered. That caused problems with the timely delivery of mail, and it actually produced employee retention problems, with one carrier quitting and another carrier transferring and another carrier filing a union grievance.
In his questioning, conservative Justice Samuel Alito seemed to suggest that companies could just pay more to workers willing to work Sunday to grant an employee's religious accommodation.
If the employer is willing to pay people to take a shift, then the shift can be covered and everybody will be happy. The employee who wants a religious accommodation gets religious accommodation, and the other employees who cover the shift, they get more money, and so they're happy.
Groff's lawyers are asking the Supreme Court to set aside a nearly 50-year precedent in TWA v. Hardison, which defined undue hardship as more than de minimis or more than a minimal cost, a move liberal Justice Sonia Sotomayor seemed to disagree with.
It costs to run extra hours, and it costs to do more work, and that cost can't be quantified always in money. So if we take the Hardison rules or holdings, that's enough, isn't it?
Before his day in court, Groff said he felt he had to choose between his faith and his livelihood.
We really can't go back and change what happened to me, but we can reaffirm the law or clarify it, however you want to put it, and keep this from happening to somebody else who has a genuine conviction about, their faith, and they shouldn't have to choose between their job and their faith.
And we are not expected to know how the justices will decide Groff's case until the end of June. Nichole?
Right. Evan, thank you. Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.